In 1989, Otis Reynolds and his two brothers, Kevin and Gavin, were murdered by two young men, one of them being Theophilus Wilson, who was later convicted and sentenced to death at the young age of 17. This past January, after spending 28 years in prison, Wilson was exonerated of all charges. New DNA evidence proved his innocence. Now, stories like Mr. Wilson's are far too common in our judicial system. Across the country, people are awaiting execution for crimes they did not commit. Not only does the death penalty constitute cruel and unusual punishment, it also violates due process and individuals' constitutional guarantee of equal protection under the law. The death penalty in the United States is unfair, uncivilized, and inequitable in practice. Today, I will argue why it is unconstitutional. First, let's discuss the Eighth Amendment. The United States Constitution states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. For centuries, there have been debates over the intention of the framers and whether they understood state-sanctioned death as cruel and unusual. It seems preposterous to think that the framers expected for society's standards of decency to remain stagnant over time, and that our pursuit of justice would be confined to 17th century ideologies and practices. At the time of ratification, punishments that were constitutional would be viewed as monstrous by today's standards. Slavery, branding, and death by firing squad were all commonplace. Are we to act under the assumption that just because they were acceptable then means they are acceptable now? When reviewing precedent that speaks to the court's view on evolving standards of decency, one can look to the case of Trop v. Dulles. In the 1958 case, the Supreme Court ruled that denationalization as a punishment is barred by the Eighth Amendment and described it as a form of punishment more primitive than torture, as it inflicts the total destruction of the individual's status in an organized society. In this ruling, the court endorsed the opinion that the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Now, let's fast forward to 2020. Slavery, branding, and death by firing squad are no longer commonplace and are deemed as cruel and unusual. However, we still continue to execute defendants by electrocution and lethal injection. Assurances about lethal injection rest on the premise that inmates are sedated and unconscious before other excruciating drugs are administered. The horrifying experiences of recent executions makes clear that these assurances are false. The drugs used in recent executions produced not a sleep into death, but many wakeful minutes of struggle and pain. Such executions are clear violations of the Eighth Amendment's prohibition on cruel and unusual punishment and require action in the form of abolition. When the court limits its rulings to applications specifically intended or expected by the framers and adopters of the constitutional text, they make it nearly impossible for evolving standards of decency to actually be applied. Apart from the cruel and unusual nature of capital punishment, the practice also denies due process of law. Enshrined in our Constitution is the assurance that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within the jurisdiction the equal protection of the laws. The death penalty does just that. It denies individuals of life. By sentencing people to death, the state is not only depriving a petitioner of a fundamental right to life, but also forever depriving an individual of the opportunity to benefit from new evidence or new laws that might warrant the reversal of a conviction or the setting aside of a death sentence. Because our judicial system is predicated on constitutional due process and justice, all judicial functions must follow fair procedures and operate within the law, particularly in death penalty cases where the sanction is forever irreversible. Although we expect all trials and sentences to be conducted both fairly and legally in the U.S., history shows us that this is not always the case. According to a study conducted by the American Civil Liberties Union, there is a substantial evidence that demonstrates that the court sentenced some petitioners to prison and sentenced others to death in a manner that was arbitrary, racially biased, and unfair. In the United States, we have a system of justice that treats defendants better if they are rich and guilty than if they are poor and innocent. When surveying the death penalty in America, there are clear racial disparities that persist in terms of sentences and executions. In fact, the study conducted by the Death Penalty Information Center found that the composition of death row has become increasingly racially disproportionate, with people of color comprising a higher and higher percentage of death row prisoners each decade. It is important to note that America's death rows are disproportionately composed of African Americans relative to their percentage of the population. When you take into account the country's long history of racial discrimination, one can understand how this is possible. In 1987, data concerning racial discrimination in capital cases was presented to the Supreme Court in McCleskey v. Kemp. In an attempt to prove that purposeful discrimination had a discriminatory effect on his trial and sentencing, McCleskey, a Black man, introduced statistical data showing the average odds of receiving death penalty sentence among all indicted cases were 4.3 times higher in the cases with white victims. Ultimately, the court did not dispute the statistical evidence, but held that an overall pattern of racial bias was insufficient. Now, a lot has changed since the ruling in McCleskey. Public support for the death penalty has declined over the past 25 years, and despite this change, the court has yet to abolish the practice. The American public feels as though the death penalty actively denies individuals due process and the right to life, and the court's decision-making process in the matter must be in accordance with the society's evolving standards of decency. Now finally, let's move on to the 14th Amendment. The 14th Amendment of the United States Constitution contains the Equal Protection Clause, which states no state shall deny to any within its jurisdictions the equal protection of laws. As discussed previously, several studies have shown how pervasive racial discrimination is in both trials and sentencing. Because of this, we have seen the same pervasiveness in the imposition and application of the death penalty on communities of color, particularly African Americans. Not only is the death penalty applied randomly, but discriminatorily. Although we expect our laws to be fair and impartial when it comes to the death penalty, we've seen that each step in the prosecution of a capital case, arrest, charging, plea bargaining, jury selection, conviction, sentencing, appeal, clemency, and execution is equally subject to the application of inexact standards of decision-making. It seems preposterous to continue with the irreversible and arbitrary form of punishment given the blatant institutional racism that still persists in our justice system. The death penalty is unlike any other form of punishment in that it's not only irreversible, but denies the petitioner of any chance of new evidence possibly overturning their conviction. According to research done by the Death Penalty Information Center, more than 172 former death row prisoners have been wrongfully convicted and sentenced to death in the United States since 1973. In many of these wrongful convictions, reprieve arrived in the last few hours before their execution was supposed to take place. Although those 172 individuals were able to receive the justice they deserved, there's evidence that suggests individuals have been tried and executed for crimes they did not commit. As a society, we must ask ourselves if we are okay with sentencing someone to death who may possibly be innocent, and are we okay to put faith in a system that has proven to be fallible? For centuries, the debate over the constitutionality of the death penalty has been one of political tension and strife. However, in recent years, shifting public opinion towards the practice has caused many to evaluate its purpose and place in a developed democracy. In the United States, the manner in which capital punishment is applied is arbitrary, discriminatory, and irrational. The problems concerning the death penalty are significant, clear, and numerous, but the solution is quite simple. This practice must be abolished, not just because it is morally wrong, but because it violates due process, the right to life, and equal protection under the law. Thank you.